All right. Give me just one more second to get set up. Make sure the stream is live. Usually a little bit of lag between when I say go and when it starts going. And looks like we might be live. I'm still getting a spinning circle. One moment. Bear with me. It looks differently for me. Just one more second to get... There we go. All right. Cool. Got the little notice it's going. All right, well, welcome to my stream. Tonight's topic is going to be how to stop judicial and prosecutorial corruption right in your own town. Because this is actually where the vast majority of corruption, of crimes against the people are perpetrated, is right in your own backyard. So I'm actually going to be outlining, and this is based on my own experience and the experience of others, how to actually act as a check on corrupt judges, corrupt prosecutors, and corrupt legislators. It's impossible to cover every possible angle on this subject in a single session, so we're going to have to take it piecemeal. But the approach tonight is going to be, let's say you are charged with a traffic citation, or you are facing a court order through family court. You know, you're having a divorce, or there's a custody arrangement, or somebody's trying to get a restraining order against you, an injunction. You know, any of those things, any criminal charge against you, or any civil suit to which a government entity is a plaintiff. This is a huge area for corruption because literally everything the government does to you, you have the right, the prerogative, protected under the Constitution to litigate, to defend yourself and others against. And so you have what they call in the schools, they have the three primary branches of government. And I think it's more than a little misleading to speak of these three branches, the executive branch, the judiciary, and the legislature, as though they, between the three of them, constituted collectively the sum total of government. That's just completely fictitious. The truth of it is, what's a branch? It's not the trunk of the tree, it's not the root of the tree. The root of the tree of government is liberty. The trunk of the tree is the people. The branches are just appendages that we have appointed or elected and delegated some amount of power and responsibility to take care of things on our behalf. However, we the people always retain ultimate power to keep our own governments in check. And this is a vital principle to understand. But what we too often see, and my friends and I have seen this, I saw it with a friend of mine just this last week, just yesterday. I was sitting in on an arraignment hearing, a pretrial hearing, in a traffic court case. And it's very interesting because it's very systematized. It's like a McDonald's, except it's nowhere near as friendly or as efficient or as tasty. It's efficient from their perspective, but because they're just trying to get the purpose of a pretrial hearing is to get a defendant to plead guilty. So and guilty pleas, plea bargaining, plea deals are actually a relatively new thing. They only became popularized, they became widespread during the last century or so. The founding fathers and even the people who were here in the United States back in the 1920s, you know, Great Depression era folks, if we were to show them the government of today, they'd be like, whoa, you guys have a police state. And like, yeah, compared to them, we do have a police state. Because back then they had maybe, I don't know, 30, 40 to maybe even 50% of their rights more or less intact. And today we have, practically speaking, it's really only about 1%. And a lot of people will say that's alarmist, and they'll say, oh no, the Constitution's totally not hanging by a thread because look, the sky hasn't fallen on our heads yet. And I'm like, well, that's the point. That's the point, is that things devolve quite rapidly as soon as the adversary has majority control. And so like if the way checks are supposed to work, like let's think about it like a vote, right? If 49 if you have a majority vote situation where like yeah, 51% of the population can vote to just exterminate the other 49%, then like you want to be really really careful to make sure that like 51% of the people never actually feel that way and never actually have that power to do that. But if they do have that power and they manage to secure that amount of vote, then 51% is actually like 99%. I hope I'm being clear here. How you only need someone only needs to control like a little more than half of the power structures to be able to trammel and engulf the remainder. And it usually doesn't take very much time from there because they can just vote more and more power to themselves and there's no one to stop them. The checks are meaningless. If you could guarantee that you could get a bill passed, because you have a majority or a supermajority to override any potential veto power. You have a president who's allied with you, and you also have control over both houses in Congress. You know, you're practically unstoppable. Oh wait, except judges. And then what do? Oh yeah, once those judges have been impeached, since again you have that majority or supermajority, that should be relatively easy to do, right? So that's actually really deadly, and this is one of the reasons why there are so many checks and balances within those three branches of government. But I'm going to show you there are also checks that we, the people, should actually be proactively applying to our government against all three branches, by the way, and they're actually more powerful than any of the checks that exist naturally between the original. I won't say the original. I'll call them the superficial branches of government. The ones that you notice, the ones that you see. Um, Maybe the trunk of the tree is less visible, and it's been intentionally concealed from us. So, I'm actually about restoring power to the people. A lot of the people in power in government today, I don't care what political persuasion you are from, they're not interested in restoring power to the people. They're interested in usurping power unto themselves, and that's what they have done. That's what they always do. So, again, the perspective here is it's you versus the government, basically. All these three branches. And this is what happens every time there's a criminal trial and every time that there is, this does include like deportation hearings, other administrative proceedings. There are like a million and one different designations that our government has just invented to try to prosecute people, including the idea that the government can sue people civilly. That was never actually a thing originally under the Constitution. That was something that they invented later, and it became a practice through the courts allowing it. It was through this thing called judicial precedent, and there's no justification in the Constitution for it. But anyways, they try to use all these different avenues. The common thread here is anytime it really is just you versus the government, and the people who have experienced this actually know for themselves that these branches of government, despite what they tell you in classrooms and government schools, they don't actually provide a meaningful check on each other internally because they're not incentivized to. They have no pressure on them from the outside, from the people, or at least wherever. They have no enforceable pressure from the people. They're not going to actually do things like judicial review of bad laws and so on. Like those things are vanishingly rare in practice, and everybody knows it. Like if you actually look at the track record, like how many crummy laws do we have getting added to the books every single legislative session? It's hundreds, if not thousands. And yet, how often does a judge actually say, hey, legislature, you might want to fix this law. It's unconstitutional. It's like once in a blue moon. And of course, it's highly televised whenever they do it. They say, oh, look, we're doing this, right? Even though it's vanishingly rare. And yeah, you do have these so-called activist judges. We're going to address that topic too. But again, okay, just picture this scenario. You are at this virtual arraignment hearing, and there's this judge who's just barking orders at people and saying, you only turn on your camera when I'm speaking to you. You're not allowed to have anyone else in the room there with you. You're not allowed to look at anyone else or talk with anyone else during this exchange here, right? And so, yeah, an officer pulled you over for speeding, you went 5 over or something in a certain area, or oh no, your insurance wasn't paid up, and so you got pulled over and you threatened to impound the vehicle. Maybe he did impound it, and now you're facing a judge, right? And you're like, wow, okay, I've got kids to feed, going through a divorce right now, and the judge is like, I don't care. I don't want to hear your life story, right? I'm just here to get one thing out of you, one thing only, and that is, do you plead guilty or not? Whoa, what's going on here, right? And sometimes they will have a prosecutor there as well to try to strong arm you into pleading guilty. So what gives? Because this is a very different dynamic. This is very, very, very different. It's a completely alien process to what was had under the Constitution originally, under the Founding Fathers, and even for more than a century, well over a century after that. Like this setting of, hey, you're just like in some, whether virtual or physical, uh, basically a behind closed doors, and it's just you and a judge and a prosecutor, and you're like, what's going on? This is why we have defendant rights. This is why we have the Bill of Rights. This is why we care about due process, so that they can't just do whatever they want to you and get whatever they want out of you without anybody speaking up for you, without you being informed of your rights, without you being empowered. Because again, yeah, this is, I want to try to paint a better picture of this, but I hope you get the picture of why it's all three branches, because it's the law, right? The legislators wrote the law, so they're against you if since the law enforcement officers allege that you broke the law, so the executive branch is against you, the legislature's against you, the judge is against you because the judge is trying to judge you, and the judge is actively, proactively trying to elicit a confession out of you. And this whole proceeding is patently unconstitutional. There is a proper way to confront people and arrest and detain them, and have a hearing, have an actual trial, and hear evidences and witnesses, and have appropriate defense and appropriate prosecution, and then come to a bona fide verdict of guilt or non-guilt. In every case, there is an actual due process to follow. We don't follow it like 99% of the time. And this is deeply, deeply concerning. And I understand a lot of people have just gotten used to it, and they're like, oh, it's okay because it's efficient. Okay, well, put yourself in the shoes of this guy or this woman. Make it relatable to you. You have to actually live through this, I think, in order truly to get it. So I do invite you to show up to these arraignment hearings, because this is what will give you the insight and awareness as to what has actually happened to our criminal justice system. And also, you can put helpful pressure on them to change this. So yeah, high level, again, and I'm going to go through this list of what you can do to stop this abuse. All three branches of government versus one isolated person. These arraignment hearings are very often not public. You have to be a lawyer or something to get into them, or they apply this very intense, very stifling, very oppressive pressure on people who are showing up. And I've heard judges say to people, ask them questions like, "Is there anyone else in the room there with you? You're not allowed to have anyone else in the room with you." And it's like, what the heck? What in the world? What's going on here? Sorry, pardon my language, but so this is really messed up, because the way a trial should work is it should be the whole public right there, facing the judge, facing the prosecutor, facing the law enforcement officers and the witnesses for and against, and providing witnesses for and against, and constituting the jury itself that's drawn from the public. It's ordinary people like you and me. And they're also hearing all these matters of the law. This gets recited. If there's a law that says, oh, you owe the government this much, we're going to, punch you in the face for going 3 miles per hour over the speed limit or something. If I'm being a little bit silly here, but if there's a cruel and unusual punishment or a very ludicrous procedure that the government's applying here, that needs sunlight on it. It needs to be exposed. So in reality, it should be the entire public facing down the judge, the prosecutor, the law enforcement, and the legislature, as well as the criminal defendant and the accusers all the witnesses, like they should be the people themselves should be observing this whole process and keeping every single one of those people in their place, keeping them accountable. It's been televised to such an exorbitant degree that we think the judge is the one who's got the authority because he's got the gavel. So boom, 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 order in the court. I order you not to speak right now. That's out of order. This is he's just an MC. That's his primary role. His MC plus he has been trained in the law, and so he can tell you what the law as written says. Right. Um, that's a helpful role. Yes, he is entrusted to make certain judgments, um, but the real boss in that setting is what I'm trying to get at here is the people themselves. Like the judge isn't powerless, prosecutor's not powerless, law enforcement's not powerless. It's just there are real checks between each of them. So I'm going to go through and hopefully we see what some of these patterns are. And yeah, so this is what I personally follow and what I advise that others do. And is this legal advice? It's kind of stupid, honestly, that we have to give ourselves a disclaimer here. And it's like, I'm trying to tell people what's true. I'm trying to act on a principled basis here. Will your government try to punish you for claiming your rights? Probably. And you'd be the one who takes the fall for that, so to speak, right? If you want to claim your rights, you have to speak up for them. You have to face any penalties, any price that they try to make you pay for claiming those rights. This is why I'm speaking up, is because I refuse to let go of my rights under any circumstances whatsoever, under any pretense. But you and I should not be naive. The system, the fake criminal justice system that we have today, the police state in quite a number of countries. I'm from the United States of America, and I am by now experienced with this in the sense that I faced this thing down myself, and I've identified these many points where they're doing things that are very, very unconstitutional. So, this is my personal way of doing things, and it's rooted in the clear principles of the Constitution. If they try to punish you for it, ultimately that's on them. That's their liability that they will have to face and account for in time or eternity. If they try to punish you for it, they might try to punish me for it. They might try to punish you for it. You've been forewarned, right? Liberty isn't cheap. So each one of these things, my hope is to just kind of drive up education and information about what can we do to stop this overreach. So arraignment. Arraignment is where it's this pre-trial hearing. And it's not the actual trial. It's just a quick meeting with the judge in advance of any trial. And over time, what's happened is they basically just try to get you to say that you're guilty so that they can take your rights away and fine you or imprison you or, take away your freedom in other ways and, put a blot on your driving record, etc., without even having to prove anything, by the way. Without having to prove a thing, without having to confront you with witnesses or anything. You just show up and they're like, you're guilty. Do you agree that you are guilty? And they use all these intimidation tactics, not least of which is isolating you. So it's just you versus all these people who pretend to know what they're doing, who seem like they know what they're doing, and seem very authoritative, and use very harsh words with you, and so on, and very, very controlling, absolute, very controlling, very fascistic, very authoritarian types of personalities. And so this arraignment, what it's morphed into is they're just trying to get you to plead guilty so they can just gut punch you, take away your money, take away your rights, and it really is the reason why I said McDonald's earlier is it's that kind of business for them. It's just a value extraction process. They're just trying to harvest resources from you and basically humiliate you, dehumanize you, right? That's the purpose of this thing. It was designed by Satan. Um, I'm not bashful about saying that. This is everybody knows this. If you've ever experienced this, you're like, oh wow, this procedure right here was literally designed by Satan. It's like, yeah, that's what you know. That's what you feel. That's what you know in that setting. So what you do there in that setting is, first of all, you make it clear. Before arraignment. They'll often have you fill out forms and stuff. Say, okay, you need to schedule when the traffic officer issues your citation or whatever. He says, okay, you need to call this number and you need to schedule an arraignment. You need to schedule a hearing. He might send you to a website, right? And on that website, there's often like a form that you fill out that says, check this box, check that box. Do you want to apply for assistance of counsel? Blah blah blah. Just so you're aware that they pretend that they're informing you of your rights, but they're usually not. They're usually intentionally obscuring your rights from you and trying to extort you into giving up your rights. Because if you check certain boxes on there, you can literally be saying, I waive my right to a jury trial, or I waive my right to counsel, etc. Right? And that's really deadly. Including they could say like, oh, I'll just take a driving class and pay a $70 fine or something like that. All this crazy stuff to where it's just like, you're giving away your rights. Don't do that, okay? So, in that setting, any other avenue that you have to communicate to the judge in advance of the arraignment, you make it clear in writing that you don't waive any rights. You can't actually waive that. Like, it's not constitutional for somebody to be like, oh, I give up my right to a jury trial. The Constitution says you're supposed to have one regardless, right? So you can't actually give it up, right? Second, you ask for a jury trial in writing. Third, ask for the assistance of counsel in writing. So if there's a checkbox to say, yes, I request assistance of counsel from this court. Do that, right? And you also have a responsibility to arrange for witnesses who can testify on your behalf. So you need to have that set up. The arraignment itself won't call for witnesses. It does help, though, if you can. I'm going to go on to the next one. Bring a friend with you and invite others to join you, whether in person or virtually. Because like these arraignment hearings, very often nowadays, they are virtual. Like when I attended both my arraignment hearing, mine was a traffic court case, and also my actual trial. My trial was arranged with a judge, and I drove down to the courthouse because it's just a little bit away, and I physically appeared there, went through their metal detector and everything at the beginning, and like the whole building is like empty except for like armed people and administrators and judges, like and their clerks and secretaries and stuff. Those are like the only people who show up. Maybe there are a handful of other government employees, but like the public seems like we're practically not invited to our own courthouses anymore. That might be a little bit different where you live, but where I live, that was the case. And ever since the pandemic, I think they were moving pretty swiftly in that direction before the pandemic as well, because of all the nice virtual technology. But anyway, both the trial and arraignment were that way. But anyway, at arraignment, let me know if your experience is different with this, by the way, because I suspect most people listening to this have actually had an encounter with like in traffic court or something like that, or being asked to pay a fine without even showing up to a court. Just being immersed by this, as to say, fined by a police officer without any due process, without any proof, and he just says, "Hey, you have a ticket for $180. Come and pay it. Pay it online, whatever. Or maybe if they're being mean, they'll require you to show up in person in a different state or something when you were traveling through, right? So, anyways, at arraignment, yeah. So it really is like this isolation chamber, and it's just you versus these government officials, and it's like there's a judge and a prosecutor, and there are no friends. You have no friends in this room, none. It's a huge problem. Like the government, like the Constitution doesn't say that the government is required to provide a prosecutor against you. I mean, implicitly, in order to prosecute a case, there has to be a prosecutor, but there's no actual constitutional requirement that says they have to provide a prosecutor to come after you, right? There is one, however, that says they are required to provide assistance of counsel for you, and you're in that little, interrogation room, basically, all by yourself against these government agents, and there's no counsel for the defense. So what do? Again, in this setting, even if you're totally alone, this is how to push back on the corrupt criminal justice system and restore the true one, restore the Constitution. Make it clear, again, verbally, that you do not waive any rights. You ask for a jury trial. And if they're decent people, they will go ahead and schedule that for you, right? You ask for the assistance of counsel. And in my state, anyway, I think this is very widespread practice, the judge will give you this battery of questions like, how much money do you make? Are you married or single? Are you divorced? Like, what's your child support payment? Blah, blah, blah. You know, really prying. And he doesn't have a warrant for that information either. So like, there's a Fourth Amendment violation if I ever saw one. Um, but and they're doing that because they've developed these rules that say you only qualify for the assistance of counsel if you make less than this amount of money and whatever other rules they have. There's no constitutional provision that justifies that. The assistance of counsel is not a value bound guarantee. It's one that you can request no matter what. And so I come back to where I started with the arraignment part of this process, which is bring a friend with you, invite others to join. They'll give you a link to the WebEx or to whatever it is where they're having the arraignment hearing. Invite others, like invite a big team of people to join you. And I think this is a great idea because at least two things. One, they'll see, even without having to be the one in the hot seat, everyone in that room, in that web conference, feels extremely uncomfortable because even if you are joining from 1,200 miles away, you can palpably feel the fire of the searing heat of the dragon's breath when the judge opens his mouth to bark at people because they have lives and because they want to claim their rights and because they're human beings who aren't hyper programmed to be all rigid in this stuffy legal system with all these rules. And they don't this is the other thing is that the people who show up to arraignments, they don't even know like what's going on. They don't even know what this meeting hearing thing is supposed to be. They're like, is this my trial? Like, because that wasn't explained to them beforehand. There's nobody who goes and actually explains to them what this thing is beforehand, for the most part. Maybe that's different in your state, in your jurisdiction, whatever. They're not particularly careful, where I'm at, to inform defendants about, like, here's the structure, here's the procedure, right? Other than to say, to do everything they can to try to stack the deck in their own favor and get you to forfeit your rights. Once you recognize that that's their purpose, you recognize you can just politely stonewall them, and yeah, just make sure you never give them an inch. Don't let them put any words in your mouth or get you to say anything that says, "Oh, I agree to waive my rights to such and such." Because I saw the judge do this yesterday. There was a defendant who was planning on self-representing, and then the judge immediately says, "You waive your right to have counsel, like, period." And she like stuttered for a second, and then he just immediately kept going, right, as though that were consent on her part, that by saying, I'm confident enough to represent myself, yes, like because he said, oh, you don't qualify for assistance of counsel because of whatever arbitrary and unconstitutional rule that he might cite to do that. And then immediately, she's like, oh, I could represent myself, right? Which they make it seem like that's the only other option, but that's dishonest. That's not the only other option, right? Besides which, and I'm going to show you some of those other options that you can exercise here. But yeah, I really do hope you go and have some of these experiences for yourself, because it's really impossible for me to share all of this with you. Oh, and the other reason why I don't have like a recording for you right now of this happening is because in order to like access the conference, the web conference for this, they make you check a box that says something like, I think I might have gotten a screenshot of it somewhere, but it says things to the effect of, I will not retransmit this, record any of this, or I can be held criminally liable and so on, and in contempt of court and so on, for making public what is supposed to be, what is required under the Constitution to be a public hearing. These guys are criminals. The criminal justice system is run by criminals, okay? So that's important to realize. And I'm not here to encourage people to get into shouting matches, but I'm here to help people to understand what they're up against and approach this in a very reasoned way to where you can actually claim and never let go of your freedoms. All right, so and yeah, that's one of the reasons why this is such a black box and why you kind of have to maybe either use your imagination, which can't do it justice, I don't think, but you really do just have to go and experience it. So I can't overemphasize this point enough. I think it's, if you take nothing else away from this, go and actually, like, you have a friend who you have a traffic citation, like, go ahead and do the hearing. Do the hearing. They might make you pay more and you're fine, but you'll learn a ton. The tuition here is extremely valuable. And if you do know someone who's going through this, if you're going through it yourself, invite others. If you know someone else who's going through it, it's like, hey, can I accompany you to the hearing? Because, like, and they might not want to, and this is one of the reasons why, this is one of the big reasons that the government people will try to push on everybody. Like, no. You don't want other people to show up to your arraignment hearing for your traffic offense because it's embarrassing. You don't want to embarrass yourself in front of the public, do you? It's like, no, actually, I know what I did and what I didn't do, so I'm totally happy to have, like, the whole world watching my arraignment hearing. Yes, please, thank you. Actually, I would love that. And that way, it's really the judge and the prosecutor that should be embarrassed by their behavior if it's remotely typical of what I've seen in these settings. So those are the ones who should be embarrassed, and they will be more and more embarrassed. Can you imagine? Just, like, picture this scene just real quick. Like, okay, yeah, there's a traffic court hearing, or there's a, if it were a family court, or for whatever crime. It's like, and oh yeah, I just invited. You don't have to tell the judge this, but, like, all right, and so is coming up to the, it's your turn in the arraignment proceedings now, and it's like, there are like 100 people there watching. It's like, because I was on yesterday, and there were maybe like 9 people in this virtual room, and I think all except the judge and there was a clerk account, just had some, like, info on a whiteboard for the people who were waiting in line there, and there's maybe some other legal officer just on there, maybe for intimidation purposes, who knows. And everyone else was a defendant, right? And then he just goes through the defendants one by one, just, it's a docket, right? And he's going through. Yeah, he saw me on there, and he calls me out. He calls me by name, and he's like, "What are you doing on here?" I'm gonna ask you to type in a private chat to me and explain to me why you're here. I'm like, okay. So I open the private chat and I say, "Hi, I'm with my friend so and so, and because she asked me to accompany her here." I didn't hear back from the judge on that, but I thought that was interesting, because I have seen in other settings judges say things like, "You're not allowed to have anyone else with you on the call," and it's just like, guys, that's a blatant violation of the Constitution. Like, and this is standard practice, and, like, we're practically forbidden to document it, and that by itself is extremely concerning. It's extremely concerning that in this proceeding, where they process like 95% of criminal cases end here with a plea deal, and they've already processed the individual, they've already punished them, practically speaking. They just need to go and exact the fine or carry out whatever sentence, right? And that's like, wow. And we're talking tens and even hundreds of millions of people get processed in this way. And, like, wait a minute, we're not allowed to invite the public. We're not allowed to, like, have a public record of this. We're not allowed to, like, raise public awareness of this. And this is why I'm doing this live stream right now, is to raise public awareness of this. And I'm looking for better means and better venues and better resources to try to educate people on this, because they don't let me, take a camera in there and be like, hey, here's what's going on. If it were a real bona fide constitutional trial or hearing, then yeah, you'd have the press show up. potentially. You'd have the public, and there'd be people who'd be like, "Yeah, I'm recording this." It's like this is public information. This is like every word that's spoken, all the audio that comes out of the, the speech that comes out of the judge's lips. That is public property. He's paid for under the public purse. These should not be secret hearings. There should be no secret proceedings and secret deals. And anyways, one other slimy tactic that was used at the I can't even go through all of them because there were so many. There was this time when it was towards the end. It was multiple times actually. The judge said to the defendant, saying, because she had requested a trial, and so she got a trial, not a jury trial, but a bench trial, which is really no different from this thing, except they take a little more time, I guess, to hash it out. A few other things we'll get to in just a moment. But the judge kept saying, go and talk to the prosecutor. You can talk. You're free to talk to the prosecutor and settle outside of court. Right? Well, isn't that cute? Isn't that cute? A judge in conspiracy to deny rights, to deny the people their rights by saying you can settle with the prosecutor outside of court. That's not the way criminal proceedings work. If you're sued civilly, that is to say literally by a fellow civilian, not by a member of the government, right? Then you can choose to settle out of court, right? Which would consist of the plaintiff choosing to retire his case and seek other means for redress, right? That's what settling out of court is. You can't settle out of court in a criminal case. That doesn't work because there are constitutional guarantees around what the due process, spell what the due process should be in criminal cases. So get the public there. I think if we could do this, we could have like 100,000 friends show up to these arraignment hearings across the 50 states over the next year. Our like constitutional literacy, our awareness at least of like just how corrupt our police state is that we have right now would blossom. And that knowledge is crucial to actually save our own lives. I can't overemphasize this, which is why I'm emphasizing it. Okay, so let's say you successfully did all those things, check all those boxes at the arraignment. You say, I don't waive my rights, I request a jury trial, I request assistance of counsel, and hey, I invited the public because this is supposed to be a public hearing. And the judge, hopefully, they have a ton of different trapdoors and levers and buttons they can push, and I haven't mapped them all out yet to figure out what all they can try to do to you. But the purpose behind putting this kind of flowchart here is to say, okay, here are some things they can do to you, they've tried to do to you at least anyway. What can you do? Because you're not helpless. You don't have to follow in their narrow little Temple of Doom style railroad track in a mine car, just careening off a cliff or into a canyon river full of alligators. So, so here's what you can do. So let's say, just for the sake of argument, that the judge says, okay, fine, I'm giving you a bench trial. The bench trial is just between you and the judge. So the judge is just like, okay, we'll meet again. Unless you want to go talk to that prosecutor. Don't bother talking with the prosecutor. You can't accomplish anything meaningful by going and talking with the prosecutor. You can't. That's my opinion. If you have evidence to the contrary and believe that you can actually acquire more rights by going and talking to a person whose job description it is to deny your rights at every point, then please let me know. But here's what you can do in the time leading up to your scheduled trial, is file a written demand for a jury trial. The judge will have a court clerk, and you file those documents with the court clerk. You can go to the court's website, find out who the court clerk is, find out how to contact that judge, and what the filing procedures are. They might vary from county to county and state to state. But you go find out what the procedure is for filing papers. Filing is a very important, it's a very formal term for court procedures, but it's very important because this is how you preserve evidence. This is how you claim and assert your rights, is through filing written motions. And they're very simple. Like, they can legally and properly consist of as little wording as, I move to I demand a jury trial. You could simply use those words, and they're legally obligated to honor the natural, native, simple, obvious, plain meaning of those words, and you know, at least evaluate your request. Right? They're obligated to respond. Many might disagree and say, like, we don't owe you a response because I've filed things without getting a response before. But this whole thing from like everywhere here on, everything on here basically is the secret menu. It's the hidden menu that they don't tell you about, that you actually can do. You can move to do anything. Frankly, those are the rules of motion procedure. You can move to do anything, and then it's taken to the body or the individual who is supposedly legally authorized to decide whether to accept that motion or not, right? To grant the motion. So you make these motions. That's what you do, and all motions have to be filed on all parties to the case. So not without getting too complex here. This is very simple. I'd be happy to help anybody who's going through this. By the way, I'm super happy to help because I've been through it. So if like this terminology is confusing to you, it's legalese. I've been through this already, and if you're facing a traffic court ticket, like if you're facing any of these shenanigans, or I don't know what just happened there, like the prosecutor just said this, the judge just said that, he gave me this kind of order, I don't know what to do from here, I think this was, yeah. They're trying to confuse you. Just to be super clear here, they're trying to confuse you into giving up your rights, right? They'll say, oh, we're trying to be super clear with you. They only want to be clear enough with you that they can get you to do what they want you to do, right? And I'm not contradicting that there could be a good judge, a righteous judge out there somewhere. I haven't seen him. I'm sorry. Not in the local courts anyway. So anyways, yeah, if you want help with this, feel free to reach out. I am not a bar certified attorney, but I am literate and I have a conscience. And I think that is a far greater head start on getting anything done that's worthwhile than a bar certification. No offense to those who have done this work, because you do have to take down the beast from within sometimes, and I have genuine hats off to you style respect for that. So let's not be petty about that. I'm not trying to claim that entire professions are worthless or corrupt, etc. I'm trying to be real with people about the status quo, and a lot of people see this as alarmism. And if you could see what I have seen, you would stop that kind of thinking and that kind of talk immediately, because you would know better. Okay, so yeah, for the trial, demand a jury trial, because they didn't give you one. They say it's going to be a bench trial. Say no. I demand a jury trial, and you can cite your state constitution as well as the federal constitution on this point. Just include this in the document. So this is let's see, Article 3. Let me scroll to that. Article 3, Section 2, Clause 3. So yeah, the Article 2, Article 3. There we go. So yeah, the article on the judiciary. It's only one page, by the way. Yeah, the trial of all crimes, except in cases of impeachment. You're not being impeached unless you're. If you are a political official who's actually watching this, please keep watching my stuff. You need to know what's in here. So the trial of all crimes shall be by jury. Period. Right? There's no, like, you can choose to have your criminal trial by jury. It's the trial of all crimes shall be by jury. Period. Right? That's what the Constitution actually says. And I brought this up to my county attorney candidate in the county races here 3 years ago. And he told me to my face, that's not in the Constitution. And then I showed it to him. His jaw dropped. He had no more words for me. And he's the guy who became our county attorney. This is sick. Okay? This is not acceptable. So, Sixth Amendment also, in all criminal prosecutions. All means all. The accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Okay, so speedy public trial by an impartial jury. So just like cite that and just grab those words, copy paste them from the Constitution, and include them in your written demand. You don't have to, because you can appeal it afterwards and you can use that language. I'll show you more about that in just a moment. but that does help. And then you sign it and you file it on both parties and on the prosecutor. So you need to find out who the prosecuting attorney is. If the judge did not inform you, you need to write to the judge and say, or to the judge's clerk and say, hey, who's the prosecutor in this case? Because I have some, and can you walk me through the process of filing? And they should help you. They should help you. A lot of court websites do have like, here's how to file motions with us. Here's where to file. And if they have like a blocking thing that says you have to be a lawyer to file stuff, don't believe it. Just phone the clerk, get his email, whatever you have to do, badger them, talk to the judge at arraignment. Actually, that's a really great idea. Is at arraignment, just say, how do I make filings on this case? The judge might even pretend that you're not allowed to. I'm not sure what the judge would say because I didn't ask that question. But you are responsible to figure out how do you file documents with the court and with the prosecutor. Because once you do that, once you're sending them, every time you file a paper with them, you send it to both parties. You do that. You want to be careful not to be frivolous. You don't want to issue motions that are like irrelevant or just what's the word? Tiresome. Yeah, frivolous. Because they can take action against you if the court deems that you are in contempt of court or that you have perjured yourself. That is knowingly making false statements. So don't make any false statements. Or if you're just they can deem you a nuisance, like what do you call it? Frivolous litigant, nuisance. I think they have some other terms in there, maybe. But basically, they can punish you if you're just flooding them with stuff that they deem to be irrelevant. And honestly, yeah, they can be kind of arbitrary about that. So you are taking a risk every time you file something. There's always a possibility that the judge somewhere is going to be like, well, I think this is frivolous. The Constitution is frivolous. But if they do that, you keep your paper trail. And you go report that to the media. Any media outlet, any organization, any group, any person, any individual, any group of people, any forum, anywhere in the United States, anywhere in the world where people care about freedom, you go and you publish that information. You go make it public. You keep that record and you publish it. Because that's one of the big pieces to get towards our end game here. I'm gonna finish going through this and hope I'm not being too tiresome. But so next things you can do. File a written request for discovery. Discovery is this process where you can say, hey, law enforcement officer and prosecutor and stuff, you got some dirt on me, right? They're like, yeah, we got some dirt on you. And you're like, may I see it? And then, the judge would be the one who, let's see, I think maybe sometimes the prosecutor's office can do it, but that's something don't quote me on that because I'm not remembering off the top of my head what the exact process is. But I do simply recall the judge redirected me to the prosecutor in my case to say, you need to, and then that was, because that's you just talking to the prosecutor. So, yeah, that's right, I think. You can file a motion with the judge to request discovery, and then the judge can order the prosecutor to go ahead and divulge whatever, and they might say no, they might say yes, right? The idea behind doing this, discovery, is, in my case, I can at least tell you what happened, is I got to look at the dash cam footage from the officer who pulled me over because my insurance app's auto pay feature had failed. And therefore he ran my license plate number and found out that my insurance wasn't paid up and that therefore he had to take away my vehicle. that kind of stuff, right? So it's great because whatever info they have and are willing to reveal to you, you can go through it. You can watch any videos. You can listen to any audio. You can comb through any written documentation they have, any evidence that they have against you. And what you're looking for there is you're looking obviously for exculpatory evidence. You might also look for evidence that they didn't follow appropriate procedures because that's important. Even though it might not acquit you of responsibility, getting eyes on it is how you keep people accountable. It's not that you're like trying to be hard on law enforcement officers. They do make mistakes. They made some mistakes in my case. I wasn't being hard on them, but I did document those things. And the reason why I documented them was to make sure that we were actually being procedurally correct, right? And being procedurally correct is important because that can make the difference between like you being in jail for 5 years versus being in jail for 1 year, or getting a $350 fine versus a $100 fine, right? And in my case, they actually, the citation that I originally had one of the charges was incorrectly entered, right? So hey, the officer entered an incorrect charge here. Okay, he made a mistake. I'm not here to rag on him for that, but that should be clarified. And I did clarify that with the judge, and the judge actually even responded courteously and said, "Oh, thank you for bringing that to our attention. Thank you for allowing us to fix that." Right. So you can actually have some cordial interactions here too. So that was a win, right? So yeah, you look for exculpatory evidence for yourself because that is the purpose isn't so that they can just nail you. It's so that you can make sure that everything is appropriate, right? If you did have a jury in this trial, or even with a judge, you still want to be able to raise valid issues and say, hey, I think that this charge is too hefty, or I think this sentence is too high, etc. You can actually contest that. And any reasonable judge would agree with you if there is real cause to say, oh yeah, you're right. I think there are mitigating factors here. A judge should have that much of a heart. Should. Asterisk. We'll get to that some more. Anyways, but yeah, anything that can help your case, you want to be aware of, right? And this discovery as well is you're looking for witnesses, right? And maybe since I'm just going to throw this out here, this would probably matter more for more serious allegations, right? But let's say you were accused of some horrible crime, hit and run, who knows, somebody got injured, maybe even died, massive property damage, whatever. You might be on the hook for something big, right? In any case, however deep your pit might seem, it is really important to request discovery if you don't personally know. And you're probably not in a position to know. It would be the officers and other people, first responders or other people who are there who would know, right? You want to go find friendly witnesses. If you're a defendant, that's a natural thing to do. And if you don't already know, if there wasn't somebody else in the car with you, you could summon, your spouse who was there in the vehicle with you at the time something bad happened or something like that, or something allegedly happened, right? You can do that. My experience is that the judges tend to view people who are your close family and friends and stuff. They tend to take those witnesses with a pretty hefty grain of salt because they're just well, of course this person would testify on your behalf, even if there's absolutely nothing material to say in your defense, just because this person loves you or likes you or has this relationship with you. And so there is that bias oftentimes. The reason why I think is very helpful as well is if you can identify witnesses. Let's say you go through that dash cam footage, and it is one of those more high stakes scenarios. Then you would want to be able to identify hey, there are these witnesses standing right here. And then you can actually ask ahead of your trial. You could say, hey, I Judge, I need you to subpoena these witnesses. So actually, I should have added this right here. But you can actually you can say, hey, Judge, I need these witnesses to appear. Can we track these witnesses down? Hey, law enforcement officers, did you obtain any witness testimony? Did you get any contact information from anyone else who was a witness there at the scene? Yes or no? Right? That's valuable to you because it shouldn't just be the prosecutor who has access to all of the people who might have some dirt on you. You should have access to them as well, in the sense of, and I understand they're witness protection things, but you want to be able, and if they summon them as witnesses, that's great. Maybe they don't summon them as witnesses, but at a bare minimum, I'm just trying to get across to how important this is. Let's say you're faced with prison for life, or prison for 15 years, or 10 years, or 5 years, or whatever, even 1 year. This is pretty important, right? It's worth you taking a day to go figure out hey, yeah, does anyone else know what happened, right? And heaven forbid, you were in a DUI or something and you don't remember what even happened, right? You want to know if there's somebody who did observe what happened, right? Because if that is exculpatory at all for you, if that benefits your case, you want to know about it. Anyways, and the law enforcement officers, the ones who are trying to nab you or trying to get you on this, they would know that too, and they might not tell you. They're supposed to tell you. You're supposed to have the ability to compel witnesses to appear on your behalf. Yeah. So, and this is again part of the due process here, to have compulsory process for obtaining witnesses in his favor. So you actually need to follow this up. And this is something I think we often forget is, yeah, if you have someone there, that was great. What if there are bystanders? The prosecution routinely summons bystanders if they think it helps their case, right? You can cross-examine them, of course, if they do. But what about, so you need to be proactive about this, is what I'm saying. Anyways, and I'm not trying to help people dodge the law or anything like that. I'm just saying, like, we want to actually act as a check against government overreach and make sure you're being treated fairly. And if there's somebody who saw, no, officer, that's not what happened, right? And look, I have footage too, or whatever. We've got 3 witnesses here who say that's not what happened, and there's 1 officer who says it did happen. What would a reasonable jury conclude? You know, so you got to do that due diligence, figure that out. Okay, I'm gonna try to wrap up here pretty quickly because I don't want to be too long-winded here. File a written request before trial for assistance counsel. If it sounds redundant, I'm hoping we learned the pattern here, right? And if you were like denied a jury trial because they say, oh, it's an infraction, you're not allowed to have a jury trial in case of an infraction, or you don't qualify for the assistance counsel because you make too much money, we don't care what your expenses are, but you make too much money, you know, $400 a week is too much money, something like that, and it's, you know, we don't care that you have rent payments, right? Of course you can go buy a lawyer, afford a lawyer, and it's just like, no, most people can't, and they know that. They don't care, because that's their job, is not to care. So what you can do here too is, in my state, they have you file a notice to the Attorney General of the state anytime you're going to challenge the constitutionality of a law, and they require you to do this as well as the jury trial demand. Both of these, really any of these, should be done well in advance of your trial date. You want to do it as soon as possible, right? So that way you can get the ball rolling, you can see what their response is, and then you can react to that response well in advance of the trial. So yeah, you can file a motion to challenge the constitutionality of the laws. This is a notice of constitutional challenge, is what it is called in my state. There are specific rules for it that you want to look up if your state has those rules. You want to look them up and just make that filing. Say, well, you know what? I can read. I have a conscience, and I can read. I might not have a law degree, but I do have those 2 things. And so anybody in the United States who has those 2 things can go do that. Just literally read what the Constitution says. Oh, the trial of all crimes shall be by jury. Right? Oh, a speedy and public trial. Okay. And what you want to do is you want to issue that challenge. And part of the reason why you do that is, even if they say no, which they probably will because they already said no, is you want to get more people involved. Get the Attorney General involved, right? And that way you're escalating it. You're already appealing it, right? Because you're saying, hey, here's bad behavior. I can tell this is bad behavior. You know, I can tell it's bad behavior. The Constitution says it's bad behavior, right? This is uncontroversial, really plain vanilla, like first grade kind of stuff. Like a kindergartner knows better than these judges are behaving and these prosecutors are behaving. So challenge it. Just actually tell them to their faces 2 + 2 = 4. And then you keep that paper trail. And the reason to keep that paper trail is because on your subsequent appeals, both through the court systems and to the public, if you have documentation of what happened, like if you can prove in their own words, according to their own office, that they said this to you, and they did this to you, and then you responded with this, and you did not, you specifically said you do not waive your right, and you do demand a jury trial, and they still said no, and they're doing all these shenanigans, all these loopholes, all these contortions to deny you your rights, you are building a very, very valuable paper trail that is worth more than its weight in gold, because now we can actually prove to the public what's happening, which is, again, like what was supposed to happen from the beginning of speedy and public trial, which they're not doing, because a lot of these pretrial arraignment hearings, where like 95+% of cases get decided, aren't even public, or they're intentionally kept very clandestine. I will very briefly mention something that did happen yesterday, and this was the judge said. So the woman who was on the conference call turned to her husband, who was off screen, to consult with him to answer one of the judge's questions. And the moment the judge saw her eyes straying away from the camera, he barked at her, "You're not allowed to talk to anybody." I'm like, what the? Okay. Because, don't you see, like, are we even literate? Like, this little bit here of, okay, assistance of counsel. Yeah. Sorry, right here. So let's track it on the screen. To have the assistance of counsel for his defense. Assistance of counsel does not mean a bar certified lawyer. It never meant that. That's not what the Constitution means. That's not what it says. That's not what it authorizes. There's literally nothing in the Constitution that says your assistance of counsel has to be somebody who's bar certified or somebody who's provided by the court or whatever. It doesn't say that anywhere. You don't have to be a professional attorney to provide assistance by means of counsel to a defendant. A defendant is at perfect liberty to recruit anybody and everybody who is comfortable doing that, anybody who consents to that, as part of their circle of counsel. That's what counsel means, is you look to someone else for counsel, for advice, for input. She was turning to her husband for some input to try to parse and understand and process and strategize around what this judge was asking her. And the judge told her that that was not allowed. That's blatantly dishonest, and it's overtly unconstitutional. And I'm not bringing this up because this is one thing that happened one time in fairyland. No, this happens all the time, and I know it's happening all the time because I just saw a judge do a ton of times to all these people. It wasn't just the one; it was all the people in this entire batch that he processed, and it happened to everybody in the batch that I observed when I was being processed. And my wife as well has also been through this, and I was locked out of the room while there was this judge, just trying to extort a plea deal out of my wife. And I'm like, yeah, this is overtly unconstitutional. It's disgusting. It's really disgusting. So that's why we're speaking up about it. So we need to bring that sunlight on it. All right, so those are things you can do pre-trial. Make sure you get everything, all your I's dotted, T's crossed. And you don't have to be a perfect lawyer to do this. You don't have to have all the legalese memorized. The main points here are that you actually never, ever, waive your rights verbally. You can't waive your rights. You can fail to exercise them, is what you can do. You can fail to claim them. They will try to coerce you into stating or agreeing, or at least failing to contest their claims that you have waived your rights. Don't let them do that, because if you don't let them do that, then you can have a stronger case that, yeah, I know what I'm doing, yeah, I know what the Constitution is, and I'm staring you in the face. And it's like that Alexander Solzhenitsyn quote where he says, "We know they're lying. They know that we know that we that they're lying. They know that we know that they know that." Anyway, however far it goes, but they're still lying, right? Exactly what's happening here. But the deeper you can go, the more obvious you can make it to all conscientious people, and the more you can make them look like the dishonest, unconstitutional criminals that they are. And to be clear, like if you have a family member who's a judge or something like that, I'm not here to I'm not here to tear down the whole profession or anything like that. It's just, you shall know them by their fruits, right? If somebody's doing this, if they're okay with this, even if this just, they went to school for this and they were trained that this was okay, like, all people were born having a conscience, right? And you are responsible to exercise that conscience. And if in your job you are routinely demanded and asked and required, whatever, to do unethical things, then you have a responsibility to help us put a stop to that. And especially when the people that you are supposed to be serving call you out on it and say, "Hey, I demand my rights. Have you never read the Constitution?" It's your obligation to acquiesce. You understand? Because you're supposed to be a defender of the people, not their enemy. You're supposed to be friendly to the Constitution. Remember, that's your oath of office. You don't have an oath to any bar or any other organization or any other paycheck or anything that supersedes that. Okay, at the trial. Number one, again, this is kind of simple. Make it clear that you don't waive any of your rights. Same stuff over and over again. Demand a jury. Again, you can issue formal motions. You can issue them in writing ahead of your trial. You can also issue them orally at trial. Go ahead and read up on the rules, and try to follow them. You might not have them all memorized. They do this for a career. They have the home turf advantage there in that sense. But your court website will typically have some rules for your state and so on. You can read up on for whatever jurisdiction. So, and again, demand a jury trial, and just wait for the response. I demand a jury trial. Hey, judge. And again, cite the Constitution. Say, the trial of all crimes shall be by jury. In all criminal prosecutions, the accused shall enjoy the right to speedy public trial. So, like, when a judge and a prosecutor realize that you actually know the Constitution, you actually know your rights, and you're claiming them, it kind of forces them to respond. It forces them to respond, or else by failing to respond, make themselves look like absolute nincompoops. And that's brilliant when you do. And go ahead and ask the judge for a recording of the trial, because they are actually obligated to give you, since this is the actual trial, they are required by law, usually even, to, like, that's usually seen as a little bit more procedurally permissible than getting a recording of a pre-trial hearing. So those are a lot more clandestine. They know that hardly anybody's going to go to the real trial, because this wasn't even a real trial, but to get a trial, because they try to make it easier, softer, to give into a plea deal and just waive your rights. But yeah, ask for the assistance of counsel again, and go ahead and point out, hey, the Constitution doesn't say I only get the assistance of counsel if I am less than this rich. And that's true. And the law as written is something we all need to understand about the Constitution. The laws can't limit the Constitution. They can't. They're supposed to implement the Constitution. A law that says, yeah, you can have assistance of counsel for your defense, but only if da-da-da. That would require a constitutional amendment. That's why constitutional amendments, that's why that amendment process exists, is to change the scope and requirements of the Constitution. Laws exist to implement those requirements and say, yeah, you get this, and here's how we're going to give it to you. And they make sure that that mechanism is adequate to cover all the cases that the Constitution requires. It's kind of like saying, you've got to travel to San Francisco. Okay, we'll build a boat to do it. Okay, and you get there by boat. We're going to go by train. We're going to go by boxcar, whatever instrument you can figure out to get there. That's the province of the law. The province of the law isn't to say, oh, actually, we're not going to San Francisco. We're going to Panama. It doesn't change the destination. Anyways, right. And again, you put the judge on notice and say, I'm challenging the constitutionality of this law, that law, that law, and you cite the reasons why. You cite the Constitution. You say here's the provision of the law. You say that no jury trial shall be had in case of infraction. The Constitution expressly guarantees the trial of all crimes shall be by jury. Is this a crime? Is this a crime, Madam Judge? Yes or no? Well. And the judge will probably try to avoid that conversation altogether and say, well, you're not allowed to argue law. You're not allowed to argue the Constitution, because we're only supposed to hear facts. That's what my judge told me, and I told her that's not true. I told her that juries are capacitated to hear matters of both law and fact, but since she did not acquiesce to my demand for a jury trial, unconstitutionally, by the way, then, therefore, she was denying, unilaterally, without authority, my prerogative to challenge unconstitutional laws. And if you do have a jury, you can say, this law is unconstitutional. And the jury, since they're human beings, and they can also be literate, and also have a conscience, they can use those wonderful brains they have, and think, well, I'm not getting paid anymore on the basis of whether we choose to convict you. And I wouldn't want to be convicted if, I don't think that's a good law. I don't like that law. It's not constitutional. You're right. It's not constitutional. Your Honor, not guilty. By reason of the law being unconstitutional. The jury is 100,000% authorized to do that. And in fact, judicial review practically never happens unless the jury does that. Isn't that interesting? So, I have a little bit more to say on that in just a moment. I have a visual graphic that I'm going to pull up. But so yeah, that would be a dream. That would be great, because if you want to actually start getting bad laws repealed, I don't know why no one's listening, but this is how you make it happen. It's not going to happen by these corrupt judges who are just part of this machine, part of this fast food, efficient prosecution system, the police state. They're not going to help you get bad laws repealed. Juries will. and assistance of counsel, and actually having the public invited, right? And if the I think there's one more point that I would love to make here. If you are going through any of this, and the judge does say something like, "Hey, you're not allowed to have other people here, or whatever," or require people to, I don't know, dox themselves or whatever, try to put pressure against assistance for counsel, do everything you can to preserve a record of that and to challenge that, because there needs to be accountability for that. If they say this is not allowed to be public, this part right here is huge. If you make it to the trial at all, major props to you. Part of the purpose of the trial is to shed light on the fake trials that 19 out of 20 people get dispatched from, because they're not even allowed to see the light of a public trial. That's really, 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 really corrupt. Okay, after the trial, if all went according to the police state's plan, then you were probably summarily convicted of however many charges. Let me tell you one more quick secret. Sorry, I was going to point this out. If you are in the state of Utah, okay, it might actually be to your benefit to ask for a jury trial if you are charged with an infraction, or sorry, if you're charged with a Class C misdemeanor in traffic court. The reason being, there's actually I mentioned the trapdoors and levers. Here's one that I've seen. They did it in my case. Ask for a jury trial. Demand a jury trial. And the reason to do that, in addition to just claiming your right, is even if you're worried about like what's the dollar amount going to be, this can actually work against the traditional plea bargaining mechanic, which is to try to extort you, try to have a heftier punishment if you do claim your rights. You can actually come away paying less for your fines and so on if you ask for a jury trial. By reason that, here's what happened in my case. I'm just going to describe it. The prosecutor showed up in my case, and I believe the reason the prosecutor was actually there at the arraignment was because I had previously demanded a jury trial. And so I show up to the arraignment and I say, hey, I demanded a jury. And the judge turns to the prosecutor and says, do you have something to say about that? To which the prosecutor responds, Your Honor, I move to submit an information amending the charges to infractions. And then the judge grants that motion. And then, poof, all of my charges have been amended to infractions. I had multiple charges because they said the officer tried to ding me on multiple things, saying, oh, your registration has been revoked and your registration is, you're driving without a valid registration. So all three things were consequent from just the insurance payment having lapsed due to the failure of the app. Anyways, and I might have known for a little bit that was the case, that it had failed. But so you have these charges, and what they do is so he amends them to infractions. The reason he amends them to infractions is because there's a Utah law that says no jury trial shall be had in the case of an infraction. And so I'm like, oh, okay, well, then I move to challenge the constitutionality of that law, right? Because that's the obvious thing to do. That's a loophole. It's a trapdoor that they set up. It's unconstitutional, blatantly so. But that's the reason why they did that. And you can potentially have, face lesser consequences if they adjust it to an infraction. And that's kind of an interesting feature of it, I guess, if you will, until they patch it or figure out some other slimy thing to do to you. They still did fine me. They definitely still did get at me over that. But I've appealed it, and I'm still appealing it right now. So actually, I got a path to file a petition to the Supreme Court, and that's where I'm at right now on that. Supreme Court of the United States. So you just keep on appealing. But yeah, handy feature. Hope it comes in useful for you. Ask for a jury trial. They might, asterisk, end up fining you less. They might fine you more. But risks you take with arbitrary tyrants. Okay, after trial. And all people can be arbitrary, to be fair. Like you could have a judge, you could have a jury who are trying to be fair and who get some things, matters of fact, wrong, and they could still botch some aspects of justice. I'm not claiming that the perfect system always results in perfect outcomes, right? Because the people who implement it are imperfect. But all right, we got to be gracious there, and that can be challenging to do. But we can do all things through the Lord's strength. So after the trial, file a petition for writ of habeas corpus. I think this is extremely important. Um, the reason for the writ of habeas corpus is that whether they granted writ for habeas corpus, it was kind of designed for it means to have the body, produce the body of, and it's designed to prevent government overreach by causing them to actually produce the witness, sorry, not the witness, the prisoner that they have detained, right? And you're saying, okay, I'm asking you to do this, but one of the really cool side effects of the habeas corpus petition is that even if they don't choose to grant your writ of habeas corpus, and even if you are not physically detained by them at the moment, simply issuing that petition, filing that petition with them, compels them to produce a transcript of, guess what? Your arraignment hearing. And this is beautiful because all of that darkness right there, you can shine a spotlight on it now. You can shine a spotlight on it because this information is now going to be transcribed or otherwise recorded, or otherwise preserved audio, what have you, right? There are some kind of minimal requirements, at least, for what information they must preserve, but they must actually preserve this now on what is called the record of your trial proceedings, which is great, because typically trial courts, justice courts, district courts are not what are termed as courts of record, meaning they don't hold themselves accountable to keep really any records for the sake of public transparency, to say what actually happened in these so-called justice courts, where you process like 99% of, or actually pretty nearly 100% of all, alleged crimes. It's like all the criminal prosecution is happening in the entire nation, except for, cases that get appealed to, high-level, federal circuit courts and stuff like that. And, there are from time to time, you'll have like a high-profile murder case that's, tried in federal court. You'll have a televised jury trial. That's like the only experience we have with jury trials. But yeah, the really beautiful thing here, again, with the writ for habeas corpus is it forces these courts that are not of record, that don't like to have sunlight on them, forces them to allow you to put some sunlight on, which is great. And then you can bring those documents, bring those receipts to the public, and then, of course, also you can appeal, and appeal. So take it to the Court of Appeals. You got a conviction for XYZ. Even if you were guilty of the alleged crime, and even if it was a totally fine and fair law in itself, and even if you broke it and it was a fine and fair law and it was constitutional, and they didn't you don't think the fine or punishment or whatever is excessive, even if all of that were true, and the judge still denied you a jury trial, or denied your assistance of counsel, or didn't let your friends participate at your arraignment hearing, or let you consult with them, or didn't, let you obtain witnesses, or challenge the constitutionality of any unconstitutional laws, any of those things, you can still challenge, you can still appeal. And you're not appealing for the sake necessarily of saying, I think I was wrongfully convicted, but like you say, due process was not followed, right? And that's a very, very big deal. And you can actually get some of those things overturned. Some of them have been overturned historically. But so much of this is to change our government, is to change the public mind. If the public mind changes enough, and if our hearts change enough, then our government will also change. They'll have to. Because they will now be being checked. Right? And so you got to leverage these things. Publicize. This is why we have the First Amendment. And this is why these rights are secured by the First Amendment. So freedom of speech and of the press, and the right of the people peaceably to assemble and petition the government for redress of grievances. Just imagine we had like doesn't necessarily have to be a march on Washington. That would be lovely. I don't suspect we're all affluent enough to be able to afford a trip to Washington, but frankly, these things are worth any price. People are being denied their rights. It would be awesome if we had like an ongoing thing, not even just a once a year thing or whatever, but like that too would be great. But these educational events, these outreach events, it's 100,000 strong, 1 million strong, 5 million, 10 million, 30 million, 50 million, 100 million Americans who are fully awake to the fact that we have these rights that are guaranteed to be protected by our Constitution, and our government isn't abiding by the Constitution. And we can articulate specifically, and we have these mountains, these vaults of evidence that we're burying our Congress in papers and proof and witnesses and testimony, and of all the corruption of these judges and of the prosecutors, the executives, and the judges. And by the way, this would completely exonerate anybody who had no wrongdoing. Because if you documented the process thoroughly, and there's somebody who did uphold due process, who didn't do anything wrong, he's scot-free. We're not going to go in like Doge, or sorry if you like Doge, but they take a shotgun to a cancer patient is what they're doing. And no matter how much you dislike what's going on, that makes the problem even worse. So we shouldn't do the same thing. We shouldn't say, oh, this police officer is guilty of all these terrible crimes. It's like the French Revolution. Just because the judge did something I didn't like. It's like, no. You've got to have probable cause. Again, like you accuse these guys of violating your rights and due process on your behalf. Therefore, you'd actually need to uphold due process on their behalf. So even the worst of the criminals, even the absolute, abjectly most corrupt judges on earth, you actually do still need to uphold honor, due process, so on. Okay, but you got to make it public. You got to share information with others. I'm sharing this information because I've experienced this, and I hope someone else encounters this, and I hope it's useful to you. I wish millions of people would go out and just have these experiences for themselves, voluntarily, document them, and keep on going, keep on descending through this procedure, so that you can learn all of the ways that we could stop these abuses. Excuse me. And just never stop petitioning for the redress of grievances. And you really do need to face down the beast. And I mean, in a sense, you kind of go deeper and deeper into the belly of the beast the more you appeal. But in the process of going into the belly of the beast, that's what I've done, that's what I'm doing here through these lengthy appeals and so on. Yeah, they're lengthy. Yeah, it's a fight, but 2 + 2 is still equal to 4. And so never give up the fight. And we're going to discover more and more of its weaknesses the deeper into this whole thing we go. As long as we are constantly holding on to our rights, we'll eventually get to a point where we can actually publicize this enough and shed enough sunlight on these corrupt procedures at the pretrial hearings, the arraignment, the denial of rights constantly, that people will actually wake up to what the Constitution really means and why it matters, and actually care enough to stand up for it. So again, the reason why like a lot of these bullet points were so redundant, a lot of them really are redundant, some of them are, you have different means available to you, mechanisms at different times sometimes, but throughout the whole process, you're basically applying for the same things. I'll just go to the Constitution and read off what these things are, and like hopefully we get it. In all criminal prosecutions, not just 1% of them, not just the felony cases, not just the capital cases, all criminal prosecutions. So that's important. The accused shall enjoy the right to a speedy, it's not speedy, document how not speedy it was, right? and public. If it's not public, document how not public it was, right? Trial, right? So an arraignment's not a trial, and it's not public most of the time. So document that. Get sunshine on that by an impartial jury. Oh, if there wasn't a jury, document that too, and always demand it. Demand everything that's in the Constitution. Say, I want it all. I'm not going to let go of a single iota of it, right? And if they give you a jury and the jury wasn't impartial because they had some unfair selection process like they had going on in the 1880s and 1890s in the territory of Utah, you document that too because you want an impartial jury of your peers, not a panel of your sworn enemies. So you hold them accountable to every single one of these things, right? I didn't go over this, but to be informed of the nature and cause of the accusation, right? If you weren't ever even told what the accusation was and what the cause was, here's why we're doing this, you deserve to demand that and document that they didn't tell you that when you demanded it, right? To be confronted with the witnesses against him. This is also a problem. Increasingly, they just don't even bother to confront you with witnesses. This is the case with, I think, the vast majority of people anymore they don't even summon the officer who pulled you over. Like, in some cases they do, and maybe fair number. I don't know the percentages, but it's definitely not all of them. To say, yeah, here's the witness. What does the witness have to say? Oh, I saw you do this, right? And I mean, in the Old Testament, in the Bible, it says you can't punish a person for a sin or a crime or anything like that if you don't have 2 or 3 witnesses. That's an important standard, I believe, because otherwise, some random Joe Schmo or just some officer who's having a bad day, like there was at least one who had a bad day and decided to charge me for having license plate light that wasn't functioning right or something. Anyways. Like, really, dude? Light bulbs burn out, okay? Anyways. So there need to be witnesses, and you need to be confronted by them to make sure that they're actually real instead of just, the government making things up or somebody hitting and running with this allegation and not even bothering to prove anything, right? And you need to have this compulsory process for obtaining witnesses in your favor. So again, that discovery part is actually quite crucial in your phase leading up to the trial, so the discovery there. Make sure you do that. And it's not just, it is asking the prosecutor's office, what do you have on me? Let me review it. Because there are some things that do obligate them to reveal some things to you. But also, you get with the judge and say, hey, what can I do? Get with anybody else that you know or suspect might have been there and say, hey, what did you see? Right? So that's a compulsory process, by the way. It's not optional. Compulsory means the judge orders, hey, we saw your license plate number, or we recognize you from the scene. Okay, the defendant recognizes you from the scene. Will you show up and testify to what you saw? We have good reason to believe that you saw something there which you were commanded to come and give your testimony. And that's not something that any, reasonable citizen could refuse, as if it's, their reasonable claims and probable cause against a defendant, and hey, you're the only other witness or whatever, as long as it's not frivolous or improbable, it's probable cause, right? Yeah, you can have witnesses in your favor. Something we rarely think about in this prosecutorial ham sandwich ordering pipeline. Let's drive through, okay? An assistance of counsel for your defense. There's no dollar amount. It says only if your case is, a misdemeanor class B or above, or only if you make less than $30,000 a year. It doesn't say any of that. You can't have a law that limits the Constitution. All right, so that's kind of the reason for this pattern of you need a jury, you need witnesses, you need counsel, jury, witnesses, counsel, jury, witnesses, counsel. And you always have the right to challenge the constitutionality of laws. You always have the right to be public and get more eyes on it and exercise the press and so on. And if it's a big story, make a big story out of it. Go make a big stink as much as you can, right? So, and you got to be careful with optics because But optics is really what a lot of this boils down to, because judges do rely on public opinion for the tenure of their offices and the perception that they are in good behavior. I'll add one more thing here, maybe two more real quick, since we're on the Fourth and Fifth Amendments. If it's an infamous crime and they didn't issue a presentment or an indictment by way of a grand jury, if the grand jury didn't actually issue a presentment or indictment, that's a nothing. That's a nothing. They can't do that. So you document that too, and you say, hey, you're trying to prosecute me by information. You can't prosecute me by information of an infamous crime. The Constitution itself says so. Document that. Demand that. Say you've got to follow due process. Or be compelled in any criminal case to be a witness against itself. This is the crux of plea bargaining. This is what plea bargaining is. They're trying to compel you to be a witness against yourself. This is what reasonable people understand to be true. Oh, they're trying to deprive me of life, liberty, and property without due process of law, or take my private property without just compensation for public use. So that's the Fifth Amendment. Fourth Amendment, the judge is prying and trying to get all kinds of, trying to get information from your household, your papers, your effects, searching and seizing information. No. I want your annual income information. No, you're not entitled to that, Mr. Judge. Mr. Okay, and then probable cause, etc. Right? And if they don't follow this in the early going, this is where the law enforcement officers could be particularly culpable. Is if they don't obtain a warrant, and if they weren't supported by oath or affirmation with particular descriptions of things to be searched and seized. If they didn't have probable cause, if they didn't back that up, this is another thing where you desperately need discovery. So in that stage, you say, hey, discovery. I want to make sure you followed the Fourth Amendment. Is an officer scanning your license plate and saying, oh, you didn't pay up your auto insurance, you didn't purchase this private market product that the government wants you to purchase? Am I secure in my person, my house, my vehicle, my papers and effects against unreasonable searches and seizures? No, that wasn't reasonable. I don't care if the Supreme Court disagrees. They're wrong if they think they can just swipe people's information just because they're on a freeway, or force them to purchase a product. Okay, sorry. Seventh Amendment, that's civil. Eighth Amendment is the other place I wanted to go real quick. And that is plea bargaining. In order to understand what it is, very simply, I'm just doing this to get the information out there. I apologize, my presentation isn't super polished or anything like that. But you can get the idea from this. Plea bargaining violates both the Fifth and the Eighth Amendments because you see what it is. A judge or a prosecutor can initiate a plea deal. Neither of them are constitutionally authorized to do so. But also the legislature is in on it. It's literally all three branches of government are in conspiracy on this point. And here's how that happens. So the Eighth Amendment reads, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So you remember the whole purpose of the judge and of all three branches of government at that arraignment hearing, that pretrial hearing, is to get you to say, oh, I'm guilty. You don't have to prove anything. I don't want to have a public trial because I'll feel embarrassed. I don't want to have a jury because I want this to be efficient and painless and quick, right? Please, let me get a police state. I want a police state because I'm just such a guilty, horrible, awful sinner and criminal, right? They want you groveling like that. That's what plea deals are designed to get. So they can fine you for, and they oftentimes claim that it's inconsequential because it's small amounts individually, but collectively, auto insurance is like $1 trillion global industry, so it's not a small matter, right? The fact that they're forcing people to buy that. That is corporate welfare at its most disgusting. Actually, there's a lot in the running for that, but that is quite disgusting. It's paved the way for Obamacare. If we didn't have auto insurance mandates, we could not have had health insurance mandates. I hope you realize that. And health insurance mandates have just been such a horrible debacle. So many people I know of, myself included, between the employer and the employee, we're paying more even for health insurance than for a 15-year mortgage. For those who have a 15-year mortgage, you look at the pricing of it, and it's like, wow, that's insane. 15-year mortgage on a modest house in Utah, and your health insurance costs more than that on a monthly basis. That's pretty grotesque. How did it get to be so expensive? It wasn't always that expensive. Like, our ancestors weren't paying more for their health insurance than for their housing, for the most part. Yeah, they might have had some very costly operations and amputations and stuff, and had as good health care, but like, didn't mean it wasn't. Anyways, separate topic to some extent, but you see where I'm going with it. All right, sorry. So I was going to explain plea deals just briefly. Plea deals are that the prosecutor and the judge want you to plead guilty so they can avoid the inconvenience and expense and inefficiency of actually following due process, like literally all of the 4th and 5th and 6th and 7th and 8th amendments, right? Well, 7th Amendment, they have some different, they have some summary disposition, they have some different, they have a different name, but they have the same effect, right? So they want to deny you your rights as a defendant, and the excuse that they have to do so is to say, well, we know you're guilty, and you know that you're guilty, and so just make it easy, right? And what's typical, like the reason why a plea deal is enticing, not just to the government, but also to the person who is the accused, the defendant, is because the prosecutor, or sometimes the judge, will say something like, well, we know that you were speeding and, going, 10 over the speed limit in this area comes with a fine of $400. But we're going to be nice to you. You see, we're actually your friends. And we're going to cut you a special bargain because we like you so much. And in that special bargain, we're going to give you a half-off deal. Maybe make you pay $250, but let's hang this carrot out in front of you at least, see how you react. And say, what if we let you get off the hook with only a $200 fine? And when you, like a college student or something like that, you're, a young parent with kids and just trying to squeak by, and the $400 fine is like, we can't afford our auto insurance payments anymore. We can't afford to own a car anymore. We'll have to walk to the grocery store for the next 6 months or whatever. This is real life, and I have real compassion for you. And that's why I'm doing what I'm doing, because I've been there, and in many ways, I still am. I'm one of you. And so, of course, that sounds enticing. It's like, oh, man, yeah, I don't have the means to go challenge this, so I guess I'll issue a no contest plea, which is the same as saying that you're guilty, right? Because you don't contest it, you're not willing to fight it, and you're relinquishing your rights by so doing. At least you're not actively claiming them. And so they're like, okay, great, cool, $200 fine, and then you also got to go take this driving class or whatever. You got to do this, pay this increased insurance premium, etc., and all these other hoops you got to jump through over the next 3 or 5 years or whatever, just to make sure that you're on good behavior, etc. And by the way, if this happens again, though, then we'll have to fine you even more through these things called enhancements, right? But so they pretend to be doing you a favor. That's a lie. And here's why. It's collusion and conspiracy between all 3 branches of government. Because, again, the judge and the prosecutor are allied. They're joined at the hip. There's no meaningful check between them. No reason for them to behave differently. But they have different offices. It's like, look to see how they observe. Look to see, is there anyone interjecting? Anyone interceding? No, there isn't. Okay, then there's no check. Like, they're the way they behave. They're playing with the same ball. They're playing on the same team. They have the same goal. So the reason why this violates 5th Amendment and 8th Amendment is, look at this. Nor shall any person be compelled in any criminal case to be a witness against himself. You know what they just did to you in that plea deal? They just compelled you to be a witness against yourself. The judge just said, tell us you're guilty. You might not think that's what the judge said. You might not say, well, it wasn't compulsion because he didn't force me to. Yeah, he did. Yeah, he did. He used force. He used compulsion. Compulsion is a very similar term to propulsion, right? Something with a pulling force, right? So if you consider like a balance, which is supposed to represent justice, right? You put a weight on one side of it, and the other side goes up, right? The other side is less weighty now. When things are just, we can go all the way back to Aristotelian logic here, but this is just math and reason and virtue and conscience speaking right here, is when things are just, when justice is being done, the balances are equal. The punishment fits the crime. It doesn't look like this. Or like this. Right? It's balanced, right? And is it a crime to say I want a jury trial? Is it a crime to say I want to exercise my rights? Because look what happened. You said, I don't want to exercise my rights. Oh, they just took some weight off of that side of the balance. Because you said you don't want to exercise your rights. That shouldn't change anything. Because there's no latitude, according to the Constitution, there's no latitude for you to say I don't want to exercise my rights. It makes no difference. You're required to be granted the protection of your rights. That's required on the government. There's no latitude, no wiggle room for them to like take weight off or put weight on. But what's actually happening is they're not taking weight off. What's actually happening is they made the weight twice as heavy as it should be. They're literally imposing excessive fines and cruel and unusual punishments through the legislature by default. That's what legislatures do. That's what they do under this corrupt criminal justice system. They're in conspiracy, and this is not uncommon. This happens like close to 100% of the time anymore. Because they know that close to 100% of cases are decided through a plea deal. So what that means is the legislature bakes that into the statutes. They say, well, we know that only like 1% of criminal defendants are actually going to claim their rights, so let's just make it so that, you know, the normal, like the normal fine is actually like half or whatever of what the law says. And that way, when the prosecutor comes along and says, I'll cut you a deal, he's going to make it look like it's a great deal. Right? And it's the exact same system as insurance. Satan is behind this whole system. Satan is absolutely behind it, and you know that he is. You can identify his influence now. I've told you this. You can feel it. You can tell that he's there, lurking underneath both of these things, which is why one protects the other. By the way, also why trying to deny people jury trials is used, leveraged, to try to protect insurance mandates, which are just socialism, theft. Okay, so they're pretending to do you a favor. They're pretending to be a blessing and a benefit to you, right? Be your friends. Reality, cruel and unusual punishments are the norm. It's just they take a little bit of that weight off. They make it a little bit less cruel, in theory, the moment you say, you don't have to follow due process. Just shoot me. Just take my money. Right? So we're literally letting them get away with violating due process, stealing our rights, imposing excessive fines and cruel and unusual punishments, because if you say, I want a jury trial, by design, they make that more expensive. They make it cruel and unusual for you to claim your rights, which is why people are disincentivized to do it. And yet, if we're wise and principled about this, we'll stand up against that, because to stop extortion, to stop blackmail, to stop ransom demands, you don't give in to the ransom Because when you give in to the ransom demands, you're empowering your enemy. Anyway, I hope this is persuasive to you. I hope this is helpful to you. Yes, the prognosis here is very, very bleak, and I understand that a lot of people don't want to stand up to this because you can indeed seem to crash and burn if you try to take the whole thing down at once. Um, Let me just say this: we can't succeed by doing that. That's true. What we can do though is we can conscientiously go and gain more experience than we have. Go and be more valiant than we have been. Go and do more than we have done. Educate others and ourselves more than we have done. And always, at all times, go ahead and just call a spade a spade. You don't have to be super invective and spicy about it. I'm probably a little more accusatory. I know I'm more accusatory than I would like to be, because there are very serious crimes against the people here that will end up costing billions of lives. This is not a joke, it's not an exaggeration. The erasure of checks and balances is what is paving the way for global nuclear war, and it will be an absolute annihilation. The prophets have foretold it. They forewarned us about it. If you're naive about that, actually go and read the scriptures for real instead of just chuckling with your favorite, board game fantasy D&D crew after Elder's Quorum or whatever. Just actually open up the scriptures and see what they have to say about our modern times. It's extremely unflattering, but I invite you to respond to those urgent and dire and very real threats in the same way that Lehi did. Because when he saw and read in a book that was revelation from the Lord, saying that Jerusalem would be destroyed and the inhabitants carried away and kept into captivity, he broke forth into praises to his God and rejoicing. And he said, because thou art merciful, thou wilt not suffer those who come unto thee, that they shall perish. And the first chapter of 1 Nephi ends with this wording, saying, thus we see that the Lord is merciful unto all those. I'm not remembering the exact word right now. Sorry, I didn't get up sleep last night, but neurons misfiring. Please forgive me my shortcomings. I know I've needed to do so much better at this, but I am trying to speak out and reach out now. I know it probably seems super fake and disingenuous just because I'm not like super wealthy and fabulously influential and super charismatic and stuff. I'm not some big political pundit or anything like that, but I'm just a guy who's doing my best to tell the truth. And you can't have it both ways. You can't say, oh yeah, we're too far gone to where we can't even raise our warning voice anymore, and at the same time say, well, all is well in Zion to the extent that we don't have to worry about this right now, or it's not our battle to fight or something. Like, we need to fight this battle and we need to win it. Whether or not you agree that this is one of the most important things for us to be doing right now, it should at least be on our docket of things to process and challenges that we need to overcome, because as long as we're doing this, as long as the statute says that this punishment should be at least twice or whatever, should have a markup on it for the exercise of our rights, that's an overt violation of the Eighth Amendment. This is conspiracy to deny the people their rights. And that's a very serious crime. And we need to provide all the documentation we can. The Lord has been very clear about this, that it's our responsibility to gather these things up. Sorry, I was just remembering from the end of 1 Nephi chapter 1. I will show unto you that the tender mercies of the Lord are over all those whom he hath chosen because of their faith, to make them mighty even unto the power of deliverance. And you have to believe that that's necessary. Otherwise, you can't be saved. I don't know that Laman and Lemuel ever bought into the idea that it was necessary, except maybe in a fleeting moment now and again, out of fear. You need to gain a testimony that it's necessary, and you need to have the character, build the character to respond like Lehi did, to recognize and see the joy in that invitation, in that information. It is not blackpilling, it's not doom pilling. I'm serious. I've been accused by people from my own excuse me, my own past elders quorum, some people I really looked up to, saying, "Oh, you're just doom pilling." Really? You're gonna tell Lehi he's just doom pilling because he has actually seen, and I have actually seen, my father has actually seen, I have actually seen that these people, the people of the United States of America, are going to be destroyed. I have seen it. And I know that God's judgments can't be withheld, they can't be turned back. But what can be done is that we individually can repent and find mercy. And you see that Lehi carries this testimony with him all throughout his life. You see it in his testimony to his son Jacob, 2 Nephi chapter 2, where he says that men are free according to the flesh. And they're free to choose liberty and eternal life through the great mediator of all mankind, or choose captivity and death, according to the captivity of the devil. For he desireth that all men might be miserable like unto himself. And that's exactly the choice that's given to us. You know, I think it's really of an atheistic mindset. And I'm not here to blame people who don't have a belief in God currently. I have to say, I think I do understand a good part of where you're coming from, because you do acknowledge the darkness that is in the world. Let me rephrase it this way. There are a lot of people who do see the darkness in the world, and there's a temptation, a tendency to feel like, well, that's the only thing in the world, right? And that does breed, it does create more of a proactive, godless mindset and an anti-God mindset. Say, well, there can't be a God because if there's a God, then why is there so much evil? But I would submit that many members of the church who even think themselves to be faithful, and who probably are faithful in a great many things, can also fall into the trap of thinking, well, my life as a member of the church is good. My life is good. There are a lot of good things. There's so much light. I love it. I'm very comfortable. Oh yeah, there's this guy I heard in the marketplace the other day in the village square, and he was saying that our country was going to be destroyed. He's a lunatic. He's just overreacting. You know, I know there's some bad things some once in a while, but like we're mostly righteous people. We're pretty good. You know, our president's doing great things, stuff like that. You know, and there is such a temptation just to believe and say like, hey, I think we're doing okay. I think we're doing just fine. You know, all is well in Zion, and yeah, maybe acknowledge a few things, you know, but God will excuse a little sin, and yeah, the wicked will be destroyed eventually, but it won't happen in my lifetime, or if it does, God will, I don't even know, I don't want to think about it, I'm going to go play video games, and read some more fantasy novels, I don't know, I'm sorry if I'm being so harsh with you guys, because, well, maybe I don't know how to wake you up, but I was there. What woke me up, actually, I used to entertain myself way too much. I used to play board games on Sundays and stuff. I wasn't awake to my blessings. I wasn't fully awake. The reason I'm bringing up this contrast, by the way, is it's so weird to see people who are arguably black-pilling. I don't know. I don't want to call it that even, but like we're like, wow, there's so much. Maybe it is doom-pilling, whatever. There's so much wickedness in the world. Like, yeah, there is. Wow. And then, you know, members of the church being like, oh wow, things are hunky-dory. Oh look, I got this new Mickey blanket. Oh look, I got these new fashion slippers. Oh look, I got this new video game. Yay, life is good, right? And we can just be so worldly, right? And we confuse our worldly prosperity for the gospel. Prosperity gospel is problematic. But you see how those two mindsets, neither of them is fully coping with reality. Like the hyper atheistic, the reject God mindset says, I can't cope with the reality that there is good in the world, and so I'm just going to deny it. I'm just going to deny that there is intelligence and beauty in the design of the human body and of the mind. I'm going to deny the reality and the beauty of love. I'm just going to chalk it all up to random, heartless, godless evolution or something really stupid like that. I don't apologize for saying that. It's true. Uh, True characterization of it. Or they're just it's so depressing. It's so nihilistic. But there's this other flavor of nihilism out there that's like, well, I just want to believe that nothing too bad will ever happen. I don't want to believe that I would actually be, required to go to the wilderness like Lehi was, or, build an ark like Noah was, or, lead a whole bunch of whiny people like Moses was, whiny and idolatrous people, and have to constantly judge and rebuke them. I don't want to have to go and carry a spear to a fornicator like Phineas did. You know, we can. I understand the temptation to shrink from real challenges, and one of the most natural man sort of positions to take is basically that those things basically don't exist. Or if they do exist, they're so far removed from my sphere of concern and influence and ability to do anything about it that, like, I can basically just keep on living whatever kind of life I want to live, and I'm gonna be okay. I'm gonna be good with the Lord at the last day because I showed up to church and I paid my tithing and I went to the temple. But you know what? Now that you mention it, I actually did really feel bad when I saw this dog attack a woman across the street, and I didn't intervene. I didn't intervene immediately. I froze up. Or I heard about someone who was treated unfairly in the family courts. And I was just like, oh man, that stinks. Well, that stinks. I'm gonna go work on my homework because like, I understand. We all have busy lives. I totally get it. I totally get it. But there does have to come a point where we just obsess less about ourselves. I understand this is hard. I've been a terribly selfish person, I'm sure. And so I'm not trying to, like, paint a halo around myself. It's we gotta learn to actually lift others' burdens, lift one another's burdens, bear one another's burdens so they may be light. We need to actually learn to love, to, like, go and punch the man who was beating his wife, like Joseph Smith did. There was a man who was in his backyard beating his wife with a whip. Joseph Smith was 15 years old at the time. He's walking down this dirt road with his buddy Porter Rockwell, who I think was 8 at the time, and hears the screams of this woman. So Joseph runs, finds the man there beating his wife. He runs up like lightning, snatches the whip out of the man's hand, socks him in the jaw, floors him. And then here comes the real commit part. Is the man is astonished on his back, saying, "Oh, who hit me?" He looks around, sees this 15-year-old boy. The man gets himself up and says, "I'm going to kill you." And Joseph commits. Joseph commits to stopping this man, no matter the cost. There's no way Joseph Smith is going to let this man go and beat his wife. No way. And so Joseph fights for his life. Hardest thing. Hardest thing. He feels at several points like he's doomed. He's dead. He's done for. This man is much bigger, much stronger. Joseph holds on for dear life, and he sees it through. And he fights with all he's got, absolutely all he's got, until the man is begging for mercy. And Joseph Smith later told the brethren, when they were building the temple in Nauvoo, this is how you have to fight for the Lord, for his house, for the work of redemption. including for our own deceased ancestors. That's the example I've wanted to follow. So, incitement to justice here, incitement to defend the innocent, incitement to uphold due process, incitement to honor your oath, to support and defend the Constitution against all enemies, foreign and domestic. You are being called upon to do it right now. What I've told you is true. Plea bargaining violates the Fifth and Eighth Amendments, at the very least. Normalizes inhumane, cruel, and unusual punishments, excessive fines. Normalizes compulsion, pressing the weight on the balance to try to get people to witness against themselves. And we should be honest about that. That's, if nothing else, again, like if nothing else, anybody who's listening to this, just tell that to the people around you. Like if you're one of those blessed souls who loves to watch your football games, soccer games, who knows what you do for relaxation and sport, I hope you'll make this your new sport. Instead of, hey babe, Redskins are on, Redskins won, whatever, you know, or if you're watching Doge and being entertained by that, or being entertained by the Wisconsin judge thing, or any of that stuff, like just make this your new sport. Hey babe, plea bargaining violates the Fifth and Eighth Amendments. Oh really? Yeah. Yeah. Legislators prescribe cruel and unusual punishments, and then prosecutors pretend to be doing you a favor by cutting you a deal. Oh, that's interesting. Yeah, I guess that is differential justice. Yeah, and they compel you to witness it. Gain experience. Like, let the truth roll off your own tongue. Use your own words to do it. But learn it. Make it your own. And say it. Because the world's not going to change any sooner than that. We're not going to put a stop to this any sooner than people actually get in the habit of learning what's true, believing what's true, and stating what's true. You might think it takes great courage to do that, but just get used to speaking your mind. You have a voice, and it needs to be heard, and it needs to be a truthful voice. I told you I'd show a little graphic on this. This is a blog post I wrote a few years ago when I was learning about jury trials, because public school didn't teach me anything about it. I call this the check on government that nobody knows about. And I just go through. So this is on what we want our grandchildren to know.wordpress.com. And I have this graphic, checks and balances. This is kind of the fairy story fantasy book picture that they paint in public schools to try to get you to believe that you should just trust the government. And you'll notice you're not in this picture of checks and balances. You say, oh yeah, we have three branches of government. There's the judiciary, there's Congress, and there's the executive branch, headed by the White House. And they all like exert pressure against each other and stuff as these three mighty pillars of government, and you can totally trust that they're separate and that they, don't overreach, etc. But this is the lie is that they're asking us to accept, is that the government will check itself. No, it won't. It doesn't. And oh yeah, and they said, oh, how do you provide a check on it then? Oh, you just vote. Vote. Whatever you do, vote. They're like all their blue hair and all their silly fake rainbow flags and stuff, and then they'd just pump kids full of Red 40, and then they'd say, oh, but it's your, whatever you do in life, have fun but don't get pregnant, and then it's your civic duty to go vote. No, it isn't. No, it is not. Emphatically, all you kids in public schools, all you anybody's, unless you have and exercise a conscience and obtain constitutional literacy, it is actually your duty not to vote. If you are not a good, decent, moral person, it is your obligation, your moral duty, not to vote. If you are a good, decent, moral person who has and exercises the gift of a conscience, and you have literacy, you have read the Constitution, you apply it, you strive to understand it, you're genuine about that, not politically motivated, but just genuinely trying to uphold the freedom of all mankind, then please do go and vote and cast your discerning voice. If you do not have that discerning voice, don't vote. Okay, but is that really an effective check against all this? Just voting? No, it really isn't. It's an extremely weak check. Just go over this for. I invite you to check this out. It's a pretty good read. I have uploaded an MP3 version of it you can listen to if you want. But yeah, voting's difficult to reverse. There's like the example of the Glunk, Dr. Seuss story. Not many people have apparently heard of it, but it's the story of this girl who thunked up a glunk. She thought up a glunk. A glunk is some kind of a monster thingy. But because she imagined it, it was there now, suddenly realized in the flesh, and she couldn't get rid of it. And the moral of the story, I guess, is that it's harder to unthunk a glunk than it is to thunk a glunk. And it's very much easier to vote in a candidate into public office than to vote him out, right? So you're taking your chances with somebody that you barely even know, if you know him at all, usually when you're voting. And once he's in there, you usually have buyer's remorse, like almost every time, perhaps every time. And so, like, he's just in there doing damage and stuff. And so, how do you stop that? And they can cause irreversible damage even if they are removed from power. So, this is kind of the moral of the story. The checks do not provide themselves, and the system, including this fake criminal justice system we've been talking about. What do you know? This is what checks and balances actually look like. So it looks like shakes and alliances. Because, yeah, and I saw this because I went and interviewed the sheriff's office candidate. I said, hey, what are you going to do to provide a check against the county attorney? Oh, by being a really good buddy with him. Really? I'm like, I raised a huge eyebrow at that one because I was just like, because that's what he told us delegates. He's like, yeah, I'm just going to be super cordial with them and super buddy. I'm like, no, that's not how checks work, sir. That's not how checks work at all. Like, being somebody's best buddy, all these handshakes and alliances, that's not how you provide a check. Yeah, you can be civil, you can be cordial, but that itself is not a check. That's an invitation to cooperate and compromise and be civil and nice with each other. Where are your teeth? Anyway, I pressed him on this. He gave me an answer. And yeah, you get this idea that governments don't conspire. In reality, they always do. And they use this fake thing they call the rule of law, which is basically them trying to assert themselves above the Constitution. I go over this in my Supreme Court case. I really do invite you to look into this. This is really important. But the key to all of this is, hey, good, look, people, we the people. You don't just show up at the ballot box and have guns with a whole bunch of ammunition stored away in a safe somewhere. Like, that's not how you provide your ultimate and most powerful check against the government. That's not how it works, right? Yes, your vote can and should guide those who are in office. It should control and decide on only good people. I'll wrap up in just a moment. But it's far from the most effective check. The most effective check is sitting on a jury and being there every single time the government is trying to get something out of one of the people. And every time the government's trying to get something out of somebody, and that somebody is accused of not following the proper procedure, then you are supposed to be there to make sure that the government follows the proper procedure in its claim that someone else did not follow the proper procedure, because otherwise you have a police state. The rule of law specified in the Constitution is jury trials. So we have the right and power to nullify everything our government does. Thomas Jefferson said, trial by jury is the only anchor ever yet imagined by man, by which a government can be held to the principles of its constitution. So that's why we gotta demand our rights, stick to them. We're not going to enjoy freedom without actually sticking up for it. So, till next time, I'm gonna check real quick to see if anybody is in the chat here. And dun, dun, dun. Seeing none on X, I'm gonna go check the YouTube avenue. I haven't been very good at getting the word out on these things lately. My apologies for that. I've been pretty busy. But I'm trying to do what I can to get the word out there. So, oh, Amy, thank you. You're on here. You're awesome. Yes, thank you so much for listening in. Yeah, and anyone who has any questions, feel free. Sorry, I think I am sometimes too rambly. You know what would help me sleep better at night? So that I'm more concise and more effective? Is more people getting the message. And that has actually already helped a lot. It helps my spirits to learn that there are other people who really do care enough about freedom to make some personal sacrifices. And I'm not asking people to make sacrifices just because, or to spend their means foolishly, or anything like that. At all points, please do follow inspiration. God knows better than I do, by a long shot. And He'll direct your life for good. I just urge and plead with you and everyone you know. I plead with you to recruit everyone you know. Enlist them for the cause of justice. Wake up the world for the cause, for the conflict of justice. It's going on right now. I used to tell people, when I was in my early college days, I referred to something I called the silent challenge. And I wish I had kept this better than I have, because it matters a ton. There are currently people who are being bombed. People are getting killed by the hundreds and by the thousands each day over in Ukraine and Russia. And in other parts of the world, there have been ongoing armed conflicts of various scales. It's really hard to understand just how real that is until it comes for you. It's really hard to stretch yourself, get outside your comfort zone enough to recognize another person's suffering until you are personally suffering. But I would remind you that that is precisely what our baptismal covenant is. That's what we pledge to do. We pledge to be proactive witnesses of God at all times and in all places. So we promise to be witnesses. Remember, that's one of the guarantees, is compulsory means to obtain witnesses in the Constitution. It's one of our guaranteed rights. But also to lift up the hands that hang down, to bear one another's burdens. That's very interesting, because if the citizens are never invited or allowed, or do not invite themselves, or do not invite others, do not compel judges to summon juries, or do not request counsel for their own assistance in their defense, or don't act as counsel, don't offer help to those who are accused and who need defense. If we're not in the habit of doing that, then are we bearing one another's burdens? Hardly. And I'm not saying these are the only burdens to bear. So please don't feel badly that there are other things to do, like grocery shopping and laundry and changing diapers and studying for school and tests and all these work requirements and oil changes and health challenges and worship in the Lord's house. Those things are all very much needed. they're all part of the whole. Everything we truly need to do. Let's get it done. All right. Well, I'm gonna sign out here and try to get some other things done. But I really do. And if anybody has any ideas for how to be more effective at getting the word out on this and just helping people, I've been trying to contact the Ward Radio guys about election integrity, and because an eyewitness to the blue shift in the Electoral College and in our state elections. I think that should be the story of the century. I think the erasure of our criminal justice system should be the story of the century. There's this book, I keep recommending it because it's so important. It's by Suja Thomas, The Missing American Jury. It's awesome. She proves within these pages that jury trials used to happen 100% of the time in criminal cases, and they only happen like 1% of the time anymore, close to zero. So, is the Constitution hanging by a thread, given that... Oh, sorry, I didn't pull up the book. Let me pull up the book. There it is. The Missing American Jury by Suja Thomas. Highly recommend it. Highly recommend it. Go to sujathomas.com/missing-american-jury, and you can get it there. And she outlines how to restore them. And I've actually been following this process. I started my own process of working on this before I found out about her book. But I really, really urge you to get together with other people and just keep on raising this issue, keep on raising the alarm on it. I know we can't always devote full time to it because there are other things we've got to do. But I've said this before, I'll keep saying it. Half of the Bill of Rights, at least half of it, more than half of its text, is devoted to the subject of defending the rights of people who have been suspected, accused, or convicted of wrongdoing. Think about that. Do you think, remember earlier I talked about 51% attacks. Do you think we're going to keep our rights if we allow more than half of them to slip through the cracks? I don't think so. Because the way they're going to do it is they're going to come for us one by one through these fake trials, these fake proceedings, and as far as they're able to isolate us one by one, they could destroy our entire nation, and they're already doing so. They are already doing so. People say I'm fear-mongering. Oh, no, I've seen this. They do this all the time. They've already normalized it. They're dismantling the people's rights, and it's not very long until this will turn into something hot. Instead of just a cold war of attrition against our people, against our means, our resources, our families, our freedoms. And no, we're not going to win it with bullets. I think that to be rather laughable, sadly. Not that I want to have a civil war. I'd much rather that we simply demand to have a jury trial and actually start having jury trials. And actually act as a check on our government, get bad laws repealed. Start putting corruption at bay. Anyways, ball's in your court. Share this around, please. I love everyone who's willing to fight for freedom. It does give me great cheer to know that there are those who are willing to follow. And I need to do a lot more. I can't apologize profusely enough for ever having wasted time in my life, and I've wasted far too much of it. I could be much more effective if I had not wasted any time. Or if I had just wasted less time, I could be more effective. And that's the basis of my indictment, but that's also I believe there's reason for hope. Like King Limhi says, I trust that there remaineth an effectual struggle to be made. Thank you for listening. Good night. Just trying to get the thoughts out there. If you have any other thoughts or ideas, please drop them in a comment. Reach out. How can we be more effective? How can we share this far and wide? May the Lord bless you. In the name of Jesus Christ, amen.